Accordingly, it is the sentence of this court, Anson Bryant, that you serve a period of incarceration in state prison. Court hereby terminates your post-release control, and I am imposing the balance through November 15th of 2020. I believe that comes up to 623 days according to the DRC's calculation. The court sentences you to prison on count 1, aggravated burglary, felony 1, for 8 years, and 3 years on the firearm specification. Court sentences you on count 3, aggravated robbery, felony 1, to a period of incarceration in state prison for 8 years, plus 3 years on the firearm specification. The court sentences you on count 6, weapons under disability, felony 3, for 36 months. And on count 7, CCW, felony 4, for 18 months. The court makes the 2 weapons charges, count 6 and 7, concurrent with each other and concurrent to all of the other charges, the offenses. However, the court makes the 2 F1s consecutive with one another. And therefore, the order of serving your prison time would be PRC time first, followed by the gun spec on count 1, followed by the gun spec on count 3, followed by count 1, followed by count 2, for a total of 22 years with credit for 231 days. The court determines that you have or will have the ability to pay restitution.
Fuck your courtroom, you racist ass bitch! Fuck your courtroom, man! You racist as fuck! You racist as fuck! Nigga, 22 fucking years! Racist ass bitch! You ain't shit! Nigga, gay surgeon, lethal surgeon told me about that bullshit.
Actually, you know what? Remember when I said that you had some remorse?
You never gave me probation.
Wait a minute.
You never gave me a chance.
When I said that you had a certain amount of remorse, I was mistaken. The court determines that maximum imprisonment is needed. So it's 11 years on count 1 and 11 years on count 3.
The courtroom turned silent as the judge delivered a lengthy prison sentence for multiple violent felony convictions, including aggravated burglary, aggravated robbery, and firearm offenses. Initially sentenced to 22 years, the defendant exploded with anger, shouting insults and accusing the judge of racism. His emotional outburst interrupted the proceedings and forced deputies to remove him from the courtroom. Witnessing his behavior firsthand, the judge immediately reconsidered the sentence, concluding that the defendant had shown no genuine remorse.
Does counsel waive the client's presence for the remainder of the advisements I have to give?
Yes, Your Honor.
All right, you can take them.
Bitch, you are a Hey, thank you, Dennis.
Love you. Thank you, sir.
Court determines that the defendant has shown no remorse whatsoever. I was giving him remorse, a certain amount of remorse in mitigation of the sentence. The defendant has shown me that he has no remorse whatsoever, and therefore the court determines that maximum imprisonment is needed. He poses the greatest likelihood of recidivism.
All right, our next file this morning is People of the State of Michigan versus Gregory Miller. Ms. Morris, do we have any victim impact statement to be made today?
I believe it's attached to the PSI, Your Honor. Other than that, no. Mr. Miller is no stranger to this court. I think the PSI does a good job in laying out a lot of his prior convictions. The biggest thing I noticed in here is, I would say almost all, if not majority of these he was either on probation, parole, or bond when these occurred. I think that goes to show he is not a good candidate for any type of probation. He has several assaultive priors, including domestic violence as well as just assault and batteries. On top of that, other domestic violences which have been pled down. He's not done well on probation in the past. He has several violations ranging from, which I think goes to show that the recommendation is appropriate in this case. Other than his prior convictions, I would just like to focus the court on the victim impact statement. Although it's short, I think it's very powerful. And I know the police report does describe the injuries that the victim suffered in this case, but in my opinion, it does not do them justice. The photos of the victim's face and injuries are extremely disturbing to look at. For lack of a better term, Mr. Miller did beat the crap out of her. And while I understand...
After the defendant was escorted out, the judge explained that the courtroom outburst completely changed the court's view. What had been considered a small sign of remorse disappeared in seconds. Citing the defendant's conduct and the likelihood of future criminal behavior, the judge increased the prison sentence to 28 years, stating that maximum imprisonment was necessary to protect the public. The dramatic moment became a powerful example of how actions inside the courtroom can directly influence a judge's final decision.
Issue of substance use disorder. Mr. Miller was homeless at the time, as the prosecution has. When Mr. Miller is sober and away from alcohol, he's a very polite, helpful, and productive citizen of this community. Unfortunately, when you throw in the substance use disorder with homelessness, this is what we end up with.
In no means whatsoever did I intentionally try or mean to harm that woman. She is a fantastic person. She's a great human being and a wonderful woman. I hope she gets the help also that I need, and I'm going to use this time spiritually, seriously, stay sober, and do my best to stay sober.
Well, the law here is for domestic violence, and it's a third offense. Typically, a domestic violence starts out as a misdemeanor, punishable by up to 93 days. But I'll tell you, what I'm looking here at is a domestic violence is any assaultive battery. For instance, if I were to push a person, that is domestic violence. If I were to punch a spouse, that would be domestic violence. This damaged her retina, gave her 2 black eyes, bruised a couple of her ribs. She had a handprint on her right arm. And I do remember the pictures from this because it was a no contest plea. When it's a no contest plea, I get to look at the entirety of the report. I don't know if the guidelines here are adequate. I'll tell you, I looked here at your criminal history, and this is one of the longer ones I've seen. This is your 9th domestic violence. 9. You have violated bond, probation, and parole countless times. So, bond supervision doesn't work, probation supervision doesn't work, parole supervision doesn't work, going in and out of prison and jails hasn't worked. And at your age, and I'm going to say this, and I don't know how to say it other than just being honest, you have led a life, and this is what I wrote down, a life of boozing and drugs since I was 8 years old. In fact, since you were 9 years old.
The hearing then shifted to another defendant with a long history of domestic violence, substance abuse, and repeated violations of probation and parole. The judge described a lifetime of alcohol abuse, violence, and failed rehabilitation efforts, emphasizing that previous opportunities for change had been wasted. After reviewing the victim's severe injuries and the defendant's extensive criminal record, the court imposed a prison sentence above the recommended guidelines, concluding that public safety had to come before anything else, and urging the defendant to finally break the cycle of violence.
Not new domestic violence charges. So you drink, you're drunk, and you beat up people. So you got a heck of a benefit. by the prosecutor's office, and I 100% believe they probably spoke to the victim and got her permission to enter this plea. Wow. 14 to 58 months. I could have given you up to 5 years, but they brought it way down. Well, these guidelines are inadequate. I don't have to find substantial and compelling reasons to exceed them. I just have to now by law find that it's reasonable. And your prior history, I can't imagine any human being looking at this prior criminal history and think what my sentence is going to be is unreasonable. It's a life of drinking and beating up people. And I wrote down here, you are a danger to women. And there's no reason to think you're not going to get back out and do the same thing, because it is all you have done for a long time. So, well, I'm going to get this $68 state minimum fee, $130 crime victims rate fund fee. I'm going to add $300 court cost, and because I don't know what else to do, I know what my prison term is going to be. I'm going to add $1,000 fine. Now, some judges will say, why? They're not likely to pay it. Every time I've seen somebody who appeals fines and costs and says it's too much, I haven't seen the appellate courts shoot it down yet. So I'm going to make you have to pay these before you can even get parole. Attorney fee, $300. No supervision fee. There's no DNA fee, nothing like that. And I'm going to sentence you to 36 to 60 months. I find that that's not only proportionate and reasonable, I almost think it's inadequate. So, and it does exceed the guidelines by just a couple months, by 7 months. I think that's a reasonable choice. It's lucky that it's not higher. So that's the sentence of the court. Stop beating up on people. Sorry, I take that back. Stop beating up on women. Alcohol daily, marijuana, and methamphetamine weekly. Yeah, let's hope you decide to stop doing it. Let's hope you decide to stop doing it. And you've also have been through domestic violence prevention, substance abuse treatment programs, advanced substance abuse treatment programs, and Catholic Human Services. Nothing's worked, so I'm just got to keep you away from people. I hope, though, you find sobriety, because you need it. And so does everyone else around you. We're here.